we are a couple minutes after 11, and we will go ahead and get started in respect for everybody's time. We are expecting several more to still log in with us. As mentioned, we will have the recording of the presentation as well as the PowerPoint slides available on the Chamber's website when this is concluded. So we're actually very pleased to have Mechelle with us today. She is an employment attorney with Shumaker and immigration labor and employment practice co-administrator there as well. And this topic that she's going to talk with us about today is actually something that we've been hearing from Chamber members, that there's some thoughts, some questions, some concerns. And so we reached out to Mechelle, and she was happy to share an overview of the business travel considerations with you. Clearly it's a very important topic, and I'm sure Mechelle could talk to us for hours as opposed to the 1 hour time slot that we have. So, but with that, again, in the interest of everybody's time, thank you for joining us, and I'm going to turn things right over to Mechelle.
All right, thank you, Julie. You know, everyone, you can chat questions throughout. Julie's going to be monitoring for that. If she thinks she needs to stop me, I'm happy to talk in between or just do questions at the end, whatever makes sense to Julie. I don't have my chat box up, so maybe we wait till the end, but Julie will monitor that.
And Mechelle, if there's something that I feel like is very topical to what you're saying, but if I think that it might be something somebody's jumping a little ahead on something you might cover, we'll save those till the end.
That's fine with me, but keep sending in your questions because we do want to answer those and not just give you a lecture what I think you need to hear. I'd rather you hear what you need to hear. So I'm going to get started. And as Julie said, I've been a lawyer with Shumaker, Loop & Kendrick for now 20 years, and hard to believe, 20 years this month. And I head the immigration practice group in the labor and employment department here for us. A lot of my work involves both, it's kind of interesting. It's both immigration side, which is dealing with international travel issues, visa bans, suspensions, and all of that, as well as advising employers throughout COVID of just how to handle this crazy situation we find ourselves all in. So, employee issues, should we do layoffs? How do we return to work safely? What do we need to do about leave requests? So I can really pretty much answer any COVID-related question you might have in regard to your employees, and feel free to ask those. Even though we're specifically addressing travel, I'm happy to talk about whatever we have time for. So, but today I'm going to start with the immigration side, and then I'll move to the employment law side. But the first thing that I think we're all well aware of is that there have been a variety of travel restrictions implemented since the start of COVID in March 2020, both international restrictions to travel abroad and for people trying to come to the US. So this is affecting everybody. It's non-essential business or pleasure travelers who are trying to get into the US, travelers seeking visas so they can come to the US for their work or school purposes that they may have planned a year ago or more, and then those who are seeking entry as immigrants, which essentially means they are coming to the U.S. as an immigrant so that when they get here, they can get their green card and they can begin, their life here as a permanent U.S. resident. You'll see me use the term, immigrant, legal permanent resident, LPR. All of these terms are somewhat interchangeable. The key difference is, all of the visa suspensions apply to those who are seeking to enter as immigrants before they've actually got to the U.S. and before they've actually been handed that green card that you get upon entry. So they're kind of in the middle of the process rather than having been here as a legal permanent resident. And please, in your chat questions, let me know if these terms get too confusing, and I'll continue to clarify because I understand it is confusing. Frankly, the government has made the same mistake in confusing those terms. So, but this applies to U.S. residents and U.S. citizens who travel outside for business and for pleasure. And it definitely affects your employees who are traveling within the U.S. for business and pleasure. So we're going to address all of this. The first sort of proclamations that were issued on travel when COVID hit, and this was in February actually, that the government suspended all entry of immigrants, non-immigrants, and other non-US citizens that were physically present in China during the 14-day period preceding entry. So this applies to anyone trying to get in here from China, and not to say they couldn't come at all, but they have to go somewhere else and wait for 14 days before they could come to the US. And that was the initial trend, and we started hearing about these closures one by one ever since, COVID really took place. And the next one to be suspended was immigrants and non-immigrants from Iran, which I found interesting. I know they had some cases that were severe, but not as severe as, say, Italy at that time, or maybe they were just a little ahead of Italy. But all of these bans on specific entries of people in those countries are related to the 14-day period immediately preceding entry, and related to the scope of COVID and its likelihood to cause a impact in the US. The next one area to be banned was actually the whole European area, the Schengen area, which is 26 countries. They're all listed below. I'm not going to read them to you, but there are 26 countries affected. That ban started on March 13th. All of these bans are still in place. We haven't seen any of them be lifted, and I expect them to remain in effect through the end of the year, at least, if not longer. Then they added on March 16th, they added Ireland and the United Kingdom. I don't think the Republic of Ireland was in there initially, but then they added it. So it's basically covering all of the United Kingdom territories, England, Wales, Scotland, Northern Ireland, and the Republic of Ireland. It does not affect the overseas territories, which is the islands that the United Kingdom may still hold. So that started March 16th. Then Brazil was added on May 28th, much later, as Brazil's cases skyrocketed. And again, it excludes, any Brazil. And then I think that was just a typo with the territories there, but but that was not sufficient, according to the government, to keep us safe. So in addition to these country by country bans, the government suspended all consular processing services worldwide effective on March 20th. So basically that meant anyone who was abroad, who was trying to come to the US to seeking a visa to be able to come to the US, whether it's for school, to visit family, because they need medical treatment, they were working, no one could get a visa stamp. So everything basically came to a grinding halt on March 20th. And made very much slowed down the amount of people entering the U.S. And that remains the case. They remain closed even to this day for most work visas and immigrant visa interviews, even if the country has a low COVID list. I have a spreadsheet that we're kind of tracking a group of lawyers through my American Immigration Lawyers Association, and it's just closed, 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 closed. They are allowing certain emergency appointments primarily for humanitarian reasons or medical workers who are assisting in fighting COVID. And just now, in the last few weeks, they have started to gradually open to foreign students who have to start school in any day now, really, now that we're into August. So they're opening to those individuals. They have opened it to athletes, professional athletes, but not even, they didn't even include Major League Soccer. It was just, football, basketball, the four main sports, football, basketball, hockey. I'm blanking on the other one, but ultimately that was just certain athletes. And then now we're hearing every once in a while someone who's an athlete or a worker of extraordinary ability can get an appointment here or there. But it's been difficult. There's no clear guideline of how to even get an appointment. I've had clients who've been trying for months and months to schedule an appointment. Some consulates say they're accepting appointments, but yet there's no appointments available. So you log in every day, try to get an appointment, nothing. They've made some exceptions that are helpful. The people who paid their visa fee like a month ago, a lot of times those expire if you don't get the appointment. Well, they're gonna extend those for a year. But basically what I've been telling everybody and what your employees need to know and your business travelers and even your pleasure travelers is that we expect enormous delays when things finally do open up, because they're going to reschedule everyone who was canceled for the last 4 or 5 months. And then we're going to go into trying to schedule the new people who are trying to get appointments. So I foresee, difficulties getting visas far after the consulates reopen and begin actually processing. The travel proclamations typically don't apply to U.S. citizens, spouses, parents, siblings, children. But they've kind of limited it. So if your parents can come, if you're a lawful permanent resident, it's the same, except your spouses can come, but your parents, as long as you are a U.S. citizen or permanent resident who is unmarried and under 21, then your parents are not subject to the proclamations that have been issued. So it's kind of like just not every parent can come. Unmarried siblings and children under age 21 can also come. Prospective adoptees can come. So if you're in the middle of adopting a child, the child can still come. Any government-related travel for COVID is permitted, and then they have their usual certain crew members, foreign government officials, and military. Again, those always tend to be exceptions to any rule. And generally, if the government has determined you would not pose a risk of introducing COVID, they will let you in. I don't know what that means. We've never heard of that, but hey, it's in there. And then those who would further law enforcement or otherwise be in the national interest typically can come to the U.S. And this is for most of the proclamations, but there are some specific exemptions I'll discuss. So the first real big suspension of immigrant visa processing occurred on April 23rd, 2020. That was something we heard was going to happen. It effectively had already been happening with the closing of the consulates in March. Nobody was getting an immigrant visa, but they made it more formal in this announcement on April 22nd, which became effective on April 23rd. But basically, it doesn't affect anyone in the U.S. getting their green card. So I got a million questions on that. But basically, if you were in the process to get your green card and you were already in the U.S., it didn't impact you. It only impacted people, and still continues to impact the people who are trying to get a visa from a consulate abroad and then come to the U.S. to pick up their green card. It didn't at that time to apply to a non-immigrant visa process. Non-immigrant is typically what we think of temporary workers, those who will work on an H1b visa or an L visa, and we'll talk about these categories, but it didn't apply to any temporary work visa at that time, but more to come, spoiler alert. But that immigrant visa suspension was scheduled to end on June 22nd. But with the non-immigrant visa suspension that came later, that was extended, and so now the new end date is December 31st, like most of these provisions. And there was a requirement that within 30 days of June 24th, they would review it, see if it needs to be modified or if it needed to remain in effect. And then every 60 days thereafter, they were to review it. And I can't tell you those reviews are happening. They don't give us any evidence that they're happening, but we have no reason to think they're not happening. So we just kind of have to go on blind faith. So the exemptions, like some of the exemptions I was talking about before, immediate relatives are considered, spouses, children who are under 21 and unmarried, and prospective adoptees of U.S. citizens. Those are considered immediate relatives, and they're all exempt. Lawful permanent residents who already have a green card, who may be abroad, they can come back in because they've got their green card already. Immigrant visa applicants who already had their interview and they got their visa stamp and they were just waiting to make their flight to come to the U.S., they can come in. So that was a good exemption because those people were so close to getting in. So Eb5 Immigrant Investors, that's a specific category who invested a large amount of money in the U.S. They can come in, and then military members can come in. I find it ironic they list special immigrants, which are essentially Iraqi and Afghani translators who have helped the U.S. government and military, although I think we've only had like 10 of those approved in the time since that category was created. So while they're not approving those, they can come in. And then immigrants serving the national interest can come in, and we're going to talk a lot about what that means, as well as immigrant healthcare workers and researchers combating COVID, they can come in as well. So the next thing to happen really was, the next big thing was the suspension of the non-immigrant visa processing. That order came out on June 22nd. As I noted before, it extended the immigrant visa ban, but that extension became effective immediately. They had to do it on that date because they needed to extend the other ban, so they did them together. We had been hearing it was coming for a long time, and you just never know when they're going to issue it. So it became effective on June 24th, 2020, and that's the key date. If you had a valid visa on June 24th, 2020, you were okay to travel. If you didn't, even if you had like an approval notice saying, hey, I'm in H1b status, but you never actually got a visa stamp to travel, which is allowed, then you're out of luck. You can't go to the consulate. You can't leave the US. You're basically trapped here. You can't go to the consulate and get a visa now. There was some thought that you might be able to, but you can't. This suspension expires on December 31, but this could also be extended. And, you know, if depending on who wins the election, will probably be extended. And then it must be reviewed again on June 24th and within 30 days of June 24th and every 60 days thereafter. So, you know, who knows if that's happening. Who it specifically applies to. So non-immigrants include a lot of different categories, but they limited it to just these basically 4 categories. H1b or H2b workers. So H1b workers are the specialty workers that are professionals that are doing, they can be doing anything from engineering, software development, accounting, doctors, anyone, you know, really any professional position could be an H1b as long as it's specialized enough. Or it can be, and it's also applying to H2b workers, which are the temporary seasonal workers. So these are people who come in to work, they may come in and work at Cedar Point for the summer. They may come and work at Disney for the summer. They may come and work at landscaping jobs for the summer, or any kind of seasonal nature work. But what was exempt was the H2A, which is agricultural workers. So they did not want to implement the foods, they didn't want to affect the food supply or agriculture, and that's why they exempted the H2A workers. And the ban also applies to any family member accompanying them. So the family member, you know, typically they're always stuck with the principal. If the principal can't get in, the family member can't get in, although there's a little unusual exception here, but I'll talk about. J1 visas, these are exchange visas that are typically used when you want to bring someone like intern or trainees, a category where you want to bring them for 12 to 18 months just to learn something about your company and take it back to their home country. It's an exchange. It's how students go to work at places like Cedar Point during the summer because they use this J1 visa. They're just an exchange visitor. They're here for 3 months. They go back. Teachers use that. Camp counselors use that. Au pairs who provide child care will use that. And then the summer work I mentioned. So those people and their family members are now barred from entering. And then the L1 visa for multinational transferees. This one was really surprising to a lot of us because, as you know, ever since the April suspension on immigrants, we had been hearing that there's going to be a ban, it's going to affect H1Bs, and we knew it was going to come, and H1Bs are often a target of the government, so we were not surprised by that. And then at the very last second, the last thing I heard before the proclamation came out is, and L visas as well. And I thought that is so strange because what L visas are for those who work for a foreign company abroad and they transfer to a US affiliate and they bring with them that knowledge of the foreign company, the US. So there's 2 categories. There's managers and executives, and then there's specialized knowledge workers. But these are all people who have a very specialized skill set that benefits the foreign company. You know, they have that knowledge from the foreign company that they bring to the US company. And that really helps the U.S. company succeed. So they are, to me, they're contributors to the U.S. economy, and it's just shocking to me that they were included. You know, the whole explanation for why they felt they needed to suspend these visas, besides just generally having an anti-immigrant sentiment, which I'm not going to go into, is to protect U.S. worker jobs. And the L1 visa, these are transferees who no U.S. worker would be able to do the job of an L1A visa holder who is an executive. You know, there's not a 1,500 U.S. workers effective if a high-level executive from a multinational company enters. So it doesn't really suit the purpose of the ban. The specialized knowledge I kind of understand more because a lot of software developers who can't get an H1b visa end up coming in on the L1B visa, specialized knowledge, and those are the workers they're trying to stop because they want to protect those jobs. So it makes a little more sense, but they also have a specialized knowledge of the foreign entities, operations that they use in their daily work. So there's a limited number of people in the US who would qualify for that job in the first place. So it's very difficult to understand some of this, but the government does what it does, and we're stuck dealing with it. So the exemptions to the non-immigrant proclamations are, you know, generally any lawful permanent resident, because you're not a non-immigrant in that case. Your spouse or children, unmarried and under 21 of a U.S. citizen, they're exempt from this. So even if they haven't gotten their visa yet, they aren't banned. A foreign national who's seeking to enter to provide temporary labor to the U.S. food supply chain, they can come in, which is helpful. And again, they're very sensitive to disruptions of the food supply chain because of COVID. And any foreign national serving the national interest as determined by the U.S. government. So they get to decide what's in the national interest. Just because I say it's in the national interest, they don't necessarily have to listen to me, which is really unfortunate. But really, what is national interest? The way it's defined is individuals critical to defense, law enforcement, diplomacy, or national security of the U.S. It's individuals who are involved in the provision of medical care to COVID-19 patients. It's individuals involved with the provision of medical research at U.S. facilities that will combat COVID-19, and then individuals necessary to facilitate the immediate and continued economic recovery of the U.S. That one really remains to be seen how broad it is. Certainly we can make some arguments, and maybe, a consulate will accept that. It's generally going to be a consular officer who decides who's in the national interest. But you would have to make a case for why they're immediately needed to help the economic recovery. And then the other category is children who would age out of visa eligibility because of either proclamation. For children who are applying as dependents of their parents, as soon as they turn 21, they're just done. They have no way of coming here again because they're no longer considered a child by definition in the statutes. So it's really important to protect their eligibility, because otherwise you have a 21-year-old who's stuck outside the U.S. and the parents are in the U.S. and that's just, not a great situation for anyone to be in, even though the kid might have a mind. Anyway, so those are the categories. Those are the way that the consular officer is going to assess any request for national interest exemption to the proclamation. But the process to make these requests is just now coming out. It's basically set up by each consulate. Some of them are putting it right on their website of how to do it. Others, there's nothing on the website and you just kind of have to send an email and guess. Others are saying, you can electronically request this through our appointment system. I mean, we're hearing all kinds of different things for the people who have started requesting these already. And a lot of times they're asking for documents to be submitted in advance, confirming the national interest impacted. Then there's a visa interview. And then sometimes they have to go back just to get the passport processed and the visa stamp put in the process. I have a client who's, head of a hospital, and his wife is a, pharmacist working to help, fight COVID. And so their au pair, which is, their childcare provider, was able to get a national interest exemption because she's taking care of the children of people who are so instrumental in the fight against COVID. But that au pair had to do 2 interviews because the first one was just to screen her for whether her work was in the national interest. The second one is to actually review her documentation and get her the visa. They're saying that these visas they're issuing are just single entry. Normally they're for multiple entries, many years or many months, or sometimes years. Now they're saying they're single entry, limited to like 30 days. It's not always being noted on there, so it's not clear that that's true, but that's the intent in any event. And so the idea is it's not for continued travel, it's for you to come to the US and do what's in the national interest and either stay or leave, but not go back and forth. So again, travel is still severely restricted. So after issuing the proclamation, the government immediately started clarifying it because a lot of the language did not make sense, or it was just unclear of what the parameters would be. I think this is a trend with every executive order or proclamation that's been issued by this administration. They usually have to take steps to clarify it almost instantly because they're just not using terms correctly, or they're not wording it well, or they're being a little vague. So they had to issue a clarification in June 29. The main clarification is that the way it was initially written, it just said you need a valid visa as of June 24th. And every attorney said, well, any visa that's valid will work. And then they immediately clarified and said, no, they have to have a valid visa in one of the 3 categories, H1b or H2b, J or L. So they immediately clarified that. The prior language was, again, just vague. They did note, a valid travel document would be effective as well. Later, I think it was a few days after the 29th, the Canadians, there was a big question about whether this applied to Canadians because, again, the proclamation was non-specific, and Canadians don't require a visa at all, so they never have a visa. So either they're totally subject, all of them, because they don't have visas, or they're exempt because they never needed a visa in the first place. And the Customs and Border Patrol did issue basically an email, which is how we get our rules these days, and said, no, nothing in this proclamation applies to Canadians. They're free to come and go since they're visa exempt. So that was very, very much a relief to a lot of Canadians and a lot of businesses who rely on Canadians who come back and forth. Initially, there was some thought that since someone was not, subject to the ban, if they had a visa valid on June 24th and they were inside the U.S. and the visa would expire later, even before the end of the proclamation, they could renew it because they met all the conditions to be exempt from the proclamation. And again, the government clarifies now and says, no, we don't think you can do that. They don't really have a basis for that. They just don't want them to come. So that's their new stance. And we'll see that one's likely to change. And quite frankly, all of this stuff is liable to change any minute. So my advice is always check with counsel before someone travels, because I look it up before I answer a question just to make sure they haven't changed a rule on me. And I read, 6 publications a day, and I have 10 Facebook groups just to discuss this stuff, and I still go and look it up before I give advice because it is so rapidly changing and the consequences are so severe if you get it wrong. More clarification on the proclamation. There was a lot of people who found themselves in the situation where they're H1b worker, they're in the US working, they have a valid visa, but their spouse has left the US and has gone to visit family or, whatever, traveling for work. And they found the spouse was, separated outside the US on the date the proclamation came down. And because we don't get any advance notice before the effective date, they were basically looking at a 6-month or longer separation, even though they may have young children in the US, and it's just creating a lot of hardships. So the US State Department very quietly put a note on their website that said, if your principal visa holder met the requirements to be exempt and the spouse is abroad, then the spouse can get the visa and come enter, even if their visa has expired. So they're making an exception for spouses. It's interesting because I checked and that announcement is still there on the State Department page, but I just have not heard very much about it. But I know it was a big relief to my clients who were in that situation and looking at months and months of separation from their spouse. So anyone who was outside on the U.S. effective date, on the effective date of June 24, if they're outside the U.S., but they have the valid H, L, or J visa, they are allowed to come back. And there was some concern because there were 2 conditions. You had to be inside the U.S. and you had to have a valid visa to be admitted. Well, then they clarified, well, if they have a valid visa and they were outside, they can come, but they just can't go get a visa that has expired. As long as, if you're on the inside the US and you're in one of these categories, you can leave and come back as long as your visa is valid. I would never recommend that, and I have told people that, but you can do it. And then they clarified also that physicians can apply for their J1 visa, which they use to get their graduate medical education. They are allowed, and they can still get H1b and L1 visas if they're providing medical care or research related to COVID. So that was a clarification. Some additional measures were added to the proclamation that were somewhat surprising. There was some direction to the Homeland Security and State Department to make sure they were collecting biometric information of travelers as required under, the pertinent regulations. So I suspect we'll see some more on that soon since they mentioned it. I don't know exactly what that's referencing. I assume there's something they're going to do to make more biometric information be collected. And that's biometric information is fingerprints, it's digital photographs, and just all these different ways of identifying who people are when they enter the US. And then they added a provision that says the Department of Homeland Security needs to take all necessary steps to prevent aliens in removal, those who are inadmissible or deportable or have committed a crime or even been arrested or charged, not just convicted a crime, from obtaining any employment authorization. And again, this is part of their effort to protect U.S. jobs during COVID and this historic unemployment. The other thing it did was to order the issuance of regulations that would give more scrutiny to those H1b workers or those who are in the U.S. applying for employment-based immigrant visas to make sure they aren't limiting opportunities for U.S. workers. So basically what that means, if you have an employee in the U.S. you're doing a labor certification for, which is the first step of a green card, or you're already in the process of applying for a green card for them, I would expect more requests for evidence or audits to determine whether U.S. workers are available for the position. We haven't seen those regs yet. I haven't even heard that they've developed those regs yet, but they've been ordered to fast track them, and I know they're trying to do that before the end of the year just to ensure it gets done before there's a change in administration, if that's going to happen. And then it asked the Health and Human Services Department to Secretary to implement measures to reduce the risk of COVID by foreign travelers. Perhaps COVID testing is what they're talking about there. So that gives you a hint on where the government is going, and so we'll be seeing a lot more proclamations, I imagine, in the next several months as time is running out. So one of those, which just came out on Monday, is a new proclamation applicable to federal contractors. And now this isn't a ban per se, but it orders the head of each department and agency who enters into federal contracts to review the performance over 2018 and 19 to assess whether the contractors use foreign workers in the US or they use offshore workers, and the nature of the work performed, and whether that affected opportunities for US workers. And, you know, really look into foreign country offshoring as well, and whether those U.S. workers are eligible for trade adjustment assistance, which is just a special unemployment program that extends unemployment for those workers. And so I think from this, we're going to see a lot more scrutiny of contractors and probably some suspensions on applying for visas by federal contractors, sadly. I mean, I think that's probably the next step. I think this was just kind of a hint to come, or a basis for the Immigration Service and adjudicating petitions to ask about federal contracts and U.S. worker opportunities that may have been impacted. So I think there's going to be a lot more to come on this. This is just our first hit. Another thing that was happening and still happening throughout COVID is the closure of the U.S. border with Canada. That's been extended to, I think, at least August 17th. They might have even extended it more since I last checked. But basically all land ports of entry between US and Canada are closed for non-essential travel. But this is land ports, and it also applies if you're traveling by boat for pleasure. But travelers who are taking flights from Canada and flying in are still being permitted to enter without having to prove an essential purpose. So I keep telling people, you know, I have a lot of clients who crossed in Detroit from Canada, and I keep telling them, you need to fly because you're going to be subject to scrutiny. I had a president of an engineering firm try to cross in Detroit just to meet with the subsidiary company and talk about their COVID response plan, and the border officer just said, no, that's not essential. And it didn't matter that the engineering firm itself is, you know, part of an automotive supplier, and that's an essential business. They didn't care. They just cared that you can do that meeting by Zoom, you can do it by phone. That's not a good enough reason to enter, and they turned him right around and sent him back. So if he had flown, he would have been here, you know, and I told him that, but he, you know, people don't always want to get on planes right now, frankly. So I read all the time, like, oh, as long as you're an essential business, you're fine. No, you're not. These officers are making the decision. And in that case, the supervisor was there and said, yep, he's right. I'm not letting you in. So it's not just a random officer. It's also the supervisors of the officers that are looking at the purpose, not just the nature of the business. The Canadian border officers are issuing treaty Nafta visas. That's a special visa for Canadians and Mexicans, as are, I think, you know, the consulates are not, because that's in Mexico, but in Canada, the border officers can do it. They are issuing L1 visas currently. You know, I imagine that they're going to stop with L1 visas because if they're non-Canadians, but they're going to still issue L1 visas to Canadians because they're exempt from the proclamation. But they're doing that at land ports. But again, I advise strongly, we don't know that they're going to do it if they think you're not essential. They may just decide not to, so you're better off going to a screening at the airport. But there's some risk there. The other thing that really is important to keep in mind, if you think you're just going to go to Canada, go to the gas station, turn around and come to the US just to activate a visa or ask for a visa, that's a real risk because Canadians are requiring a 14-day mandatory quarantine for anyone who enters Canada right now. So you could enter Canada, they could say you have to go to 14 days of quarantine, and when you turn around to try to go back to the US, they'll say you didn't do your quarantine, you have to wait. So there is a risk of that, or you could just be rejected for not being essential. So you really need to warn your employees who think they're just going to travel into Canada for a half hour to get their visa and come back, that plan may not work, and you may be better off filing with the U.S. Immigration Service here, which you're allowed to do. So what is essential travel between US and Canada? Generally, business travel is essential and pleasure travel is not. So you can't just go see your mom or your grandmother. But again, they are looking at the purpose of the business travel and will deny if it's not deemed essential, and their sole discretion. So you don't really have an appeal of that. Best thing you can do is try again. Usually a letter from the company may help, but I say just go on the flight. That's the only way you're going to really get in if you've already been denied. Working for a business that was allowed to stay open during a stay-at-home order is not sufficient, even though they're considered essential because they stayed open despite the order. That's not enough. Travel for humanitarian reasons or what's considered the national interest will be permitted, in CBP's discretion, even if it's not essential travel. So traveling for medical care or someone's dying, that may work, but no guarantees. From the Canada side, those foreign nationals who are committed to living, working, or studying in Canada are going to be permitted to travel to Canada, even if they aren't Canadian citizens. So Canada has said their travel is considered essential. But who is an essential worker? If you're looking at the purpose, U.S. citizens and lawful permanent residents can come. Individuals receiving medical treatment can come. Individuals traveling to study can come, but if it's all online, the border officers could say, hey, we're not going to let you travel just to do online classes in the US. You can do that from anywhere. So I think that's still a risk. There was a big issue with foreign schools having to have in-person classes, and actually the government retracted that rule. You may have heard about it. That was a good result because it was going to wreak havoc on the educational system. So all online classes is possible for foreign students studying in the US. Individuals traveling to work in the US when travel is required as part of their job are generally essential, but like I've told you, the reality is they're looking at the necessity for travel too, not just the fact that travel is part of your job. Individuals traveling for emergency response, individuals engaged in lawful cross-border trade, like truck drivers, will be allowed with their cargo to cross, and then of course official government travel, diplomatic travel, military members are allowed. So I guess I went faster than I thought, but I'm already at the regional US travel. So now I'm just kind of bringing it back home. I want to put on my employment law hat and talk about, is it a good idea to tell your employees you can't travel while you're working for this company, or to limit them or make them disclose their travel? I mean, I think there's a lot of issues here. And in a lot of states, there's a couple of states at least, Colorado's one, New York is one, you can't terminate an employee for something they do lawfully in their recreational time, off work time. So like in those states, you couldn't do this, but in Ohio, we don't have a rule like that. But I think there's still some risks in limiting travel. Just for instance, if someone has a family member they need to take care of in Michigan and you're in Ohio, you got to let them do that. That's Family Medical Leave Act, and that's allowed. But you can say, you can educate your employees and you can encourage them not to travel. You can explain the risk to their coworkers if they do travel. And you can implement a mandatory quarantine, when they get back, and just say, well, if you do travel, that's fine. We're not going to fire you, but we're going to require you to stay home for 14 days because you've exposed yourself potentially to COVID. I think that's fine for a private employer. I think public employers need to really talk about this with their counsel and see, are there free speech implications? Is there some sort of government action that could be imputed that could be problematic? So I think public employers have a little more risk there. You know, what we've found is the travel restrictions or real strict rules of you have to report all travel. They can really impact employee morale and mental health, and it's a hard enough time. And I'll tell you, I'm seeing a lot of issues of employees just not getting along or expressing unhappiness that they never expressed before for all the same things, because everybody just feels really stressed. And these travel restrictions can have an impact on morale and should be considered. That's why I prefer the educate and encourage route rather than a prohibition, or if you prohibit it, you need to not, I wouldn't recommend anyone terminate anybody for travel right now. I just think it's risky. I would say you need to, you know, have the quarantine, but don't necessarily discipline in travel. Can you have employees just notify you of their travel plans? Absolutely, that part is fine. And really your obligations under the Health and Safety Act sort of mandate that in order to keep your workplace safe, you need to know who's traveled. And part of that is you need to understand their role when they get back to the office after the travel, and understand how much do they interact with people, how much do they interact with your customers, what risks do they pose, and really, are you implementing social distancing, masks, all those requirements? Because if you are, you should be able to keep people safe. But to me, I'm not sure I would have employees quarantine for 14 days if they can safely work remotely. You know, let them work remotely. That's a great solution. I certainly, you know, if they come to work in an office and they have very little contact with other people, I'd probably at least have them stay out 5 days. I don't know if I'd have them stay the 14 days. I think it just depends on the nature of the work. But if you're in a, you know, manufacturing setting where people are side by side and you can't get them to keep their mask on because they need to talk to each other or other work reasons, then, you know, you're much better off having that employee stay home. So what are the risks of regional U.S. travel? Well, some places are not allowing people to come, you know, for one thing. If they're flying, there are canceled flights or they're limited flights, so they may think they have a flight, then they can't get another one for 5 days. They may need time off work when they get back to self-isolate, and the CDC is recommending a 14-day quarantine. And then discrimination claims, I mean, you have to be, as with every employment rule, you have to be sure that you are applying your rules fairly and evenly, and not looking at who's in a protected category and not looking at where they're traveling to. You know, if you're just making people who go to Mexico quarantine and not people who go to Brazil, you know, then you're doing that could be national origin discrimination. Or the same thing, you know, people from Italy where there was a real hot spot and people don't have to quarantine, but people from Brazil do, that seems like it's discriminatory. So you have to be even-handed, as with all work rules, and have a rational basis and a job-related basis for why you're requiring, you know, a quarantine and for how long. It was a little easier in the beginning of COVID because the governor's orders specifically address travel. Now they don't, but they recommend limited travel, and the CDC continues to recommend limited travel and a 14-day quarantine upon return. So you still have those to rely on. I would make sure you're documenting that. I'd print out the CDC page that says limit travel. We recommend you limit travel, and put it in with any decision you make. But again, I think the decision should be to keep someone off work or let them come back, not to fire them or discipline them otherwise, because they are engaging in personal travel and it is a little sticky. Moving on to the risks of business travel. Now, business travel is harder because you know, the fear, I think every employer's fear is, if I send my employee to Florida for a meeting and they come back with COVID, am I liable to him? Am I liable to, you know, the employee and the employee's family, or to anyone they encounter on the way back? And, you know, I don't think there's clear liability in that situation, but I think that the one thing the responsible employers can do is limit business travel in all cases where they can do so. And in some cases you just can't. But I think the risk of liability, that's a lot harder to prove. And just going into, you know, most employees who want to file a claim against their employer for a medical condition that say they contracted COVID while they were traveling for work, they would have to show that their work exposed them they would actually have to file a workers' comp claim because you are immune from civil liability to an employee, except in a certain special case I'll talk next. But generally, if they're filing a workers' comp claim, they have to be able to show that their work exposed them to a greater risk or greater hazard than the general public faces generally. That is a difficult standard to meet because, in fact, a lot of workplaces may be safer than the grocery store or the gas station because, employers are doing a lot to socially distance, to sanitize, to require mask uses. So that alone is hard. But even with the travel, is the person who travels to Florida for work at any greater risk than walking around downtown Toledo? I don't think so. So those are real concerns, but nobody wants to face that claim and have to fight it either. Could they sue you civilly? Only if they have enough evidence to show that you intended to injure them such that you disregarded all risks. So it's like it has to be extreme behavior, like removing a safety guard. It would be one way. With COVID, it would be, sending in the middle of a hotspot with no equipment no way to protect themselves. And, we would hope that no employer would do that, but you would, train your employee to socially distance, to sanitize, to wash their hands, to use gloves, to whatever it takes, to face coverings, whatever it takes to keep them safe during the travel. One of the other concerns down here is the Families First Act. A lot of you who are under 500 employees are subject to this act, which is the Paid Leave Act. So you give employees 80 hours of emergency paid sick leave, or there's 12 weeks of childcare leave. Just talking about travel and quarantine people when they get back to work, do you have to pay for that? Well, you may have to under the Families First Act if they come back with a doctor's note that says they need to self-isolate due to concerns with COVID. Even if it's related to travel that you told them not to take, you still have to pay that. Now, the good news about that act is that you apply for a tax credit and the government reimburses you for 100% of that cost, and it's limited to 80 hours. But I think you would have to pay that if they come up with the doctor's note. Now, if they don't have a doctor's note and there's no health department order and they don't fit any of the other 4 categories, then you would not pay them under that act. But you should give them access to PTO or vacation for that leave if they have it available. And then if they don't have it available, then it can be paid or unpaid at your discretion. So to summarize, because I'm getting down to the last 10 minutes and we want to save some time for questions if there are any, the best practices is to, as I said before, I probably should have wrote that on here, but educate and encourage not to travel and make sure employees understand why it's important. If they do travel, continue monitoring of employees after return, making sure they're symptom-free if you do let them back in the workplace, or letting them remote work if that's possible. Obtain a fitness for duty from their doctor. You can do that, but I would apply that to everyone who travels during COVID. As long as you apply it equally, that's reasonable. It's sometimes hard right now to get those notes from doctors or get into the doctor, but if they can do that, you can require that and maybe just be more gentle on the time frames to make sure the doctor's available. Require self-isolation after travel. That's reasonable, especially if symptomatic. If they have symptoms, you definitely want them out of the workplace. That's just black and white. Allow the use of PTO or vacation during this time is a good idea. A lot of people have already used that, so they may not even really help. And then again, it's probably best not to discipline, just to impose, the self-isolation from the workplace, and maybe that's unpaid and that's penalty enough. So I'll turn over to Julie and see if there are any questions we need to address.
Thanks, Michelle. We actually did not get any questions in the chat box yet. So
okay.
You were so thorough as you went through, so we will wait a second here.
Okay.
If somebody has a question that they're maybe trying to figure out how to write, go ahead and raise your hand and I'll go ahead and unmute you, and that might be a way that we can handle that as well. But otherwise, nothing has come in on the chat for that.
Okay. Well, some of these issues are easier to just discuss afterwards. So if anyone wants to reach out, Julie can make my contact information available, and I'm happy to answer any additional questions separately.
Oh, hold on, we've got something.
Okay.
What about, what about travel to India for business?
Well, India was one of the countries that was closed early on. I think it's open now, but what I'm hearing about India is that it's really hard to get a flight. Like, you can't even get a flight to India right now. I have someone who's been trying and trying. So I don't know and I don't know offhand if India has a mandatory quarantine when you arrive. That's something you would want to check. But if you can get a flight and you're comfortable that you can get a return flight, then I think that it is permissible right now. All right. That was easy. More like that.
Yep. Again, I will send everybody who is on this call a link to when this recording is up on our website. It will include the PowerPoint so that you have a lot of that kind of specific written information. And I will include Michelle's personal contact, her work contact information in there. Again, as you said, Michelle, some people may have questions that are very specific,
right?
And not something to really put out there to the whole group, and we certainly respect that. But thank you so much for your time and this great information. And for those of you who joined us today, we appreciate that and hope you have a great afternoon.
Okay, thanks.
Thank you.